Since some people have asked me, I am making my EPS95 video in English also. First, I would like to bring the main aspect of the Employees Provident Fund Act 1952 and the schemes. Please remember, when I refer anything contained, any provision contained in the Act, they are called sections. If I refer a scheme, anything contained in the scheme is called a para. So there is a difference between the section and the para. This EPF and MP Act, Employees Provident Fund and Miscellaneous Provision Act, has been enacted in the year 1952. And in the same year, Employees Provident Fund scheme has been enacted with the intervention of Central Provident Fund Commissioner, Ministry of Labour, and Central Board of Trustees. That means the main difference between the Act and the scheme is the Act will be an enactment by the Act of the Parliament, which receives assent of the President and everything. Then it will publish it in the official gazette, and from then it will become a notified one, and which will be binding on all the persons, all the members, and all states and all territories which has been specified in the section 1 of the Act. That is called extent, title, and commencement. But whereas scheme, for the administrative purposes, will be under control of the Central Provident Fund Commissioner, the Central Board of Trustees, and also the Ministry of Labour. The main purpose of enacting a scheme, it will contain more broad features than the Act, which will contain various forms, various paras, and any other extra concession which the officials feel to be incorporated, they will incorporate. So that's the reason why the para 26.6 of the scheme has been put over there for creating the provision for the employer and the employee to contribute for higher salary than which has been prescribed under the Act. To do anything, any amendment in the Act, it requires an act of the Parliament, but whereas the scheme is not so. Scheme will be under control of the Central Provident Fund Commissioner and the central government, which is appropriate authority to make amendments to the scheme from time to time. So after the enactment of this particular Employees Provident Funds and Miscellaneous Provisions Act in 1952, nearly after 43 years, this Employees Pension Scheme 1995 has come into picture on 16/11/1995. Even before that, there was a scheme called Employees Family Pension Scheme, which was which was formed in the year 1971, which has been repealed by this particular Employees Family Pension Scheme, Employees Pension Scheme in the year 1995, that is 16/11/1995. Like the para 26.6, there are paras called 11.3 and 11.4 in Employees Pension Scheme 1995. Before introduction of para 11.4, with an amendment of GSR 609E on 22 August 2014, there was a para only 11.3 which got introduced in the year 1996, claiming that those employees who wants to claim higher pension can contribute more than the ceiling limit of 5,000 rupees or say 6,500 rupees on the day when they exceed that particular salary limit. But according to several judgments which have been released in favor of or against this particular 11.3 paragraph, it has been held that the provisions of para 11.3 has been wrongly interpreted, and the cut-off date has been wrongly interpreted by authorities, by which the actual members who are eligible to opt for the scheme, they could not do so. Then after that, when 19/2014 that new amendment has been made by para 11.4. It has stipulated one condition that those persons who have already exercised option in 11.3 should also renew their option under section 11.4, under para 11.4. And for such of those persons, they have given a time limit of 6 months from the date of notification. And by any chance, if they are unable to do it, they have given another extension of 6 months more. Total, they have given 1 year of time from 1/9/2014 to exercise fresh option under the para 11.4. While creating para 11.4, it was also mentioned in para 11.4 saying that those members who want to contribute more than the statutory limit, by 1/9/2014, an amendment to the ceiling has been brought over to 15,000 rupees. Those who want to contribute on higher wages for the pension, their pension will be dependent upon such a kind of higher wages, but that employee has to pay 1.16% on extra contribution on higher wages according to the para 11.4. So the Rajasthan High Court, Delhi High Court, and as well as Kerala High Court, these three high courts in different petitions led by Kohli and R.C. Gupta and others, several matters. Certain things have been precipitated by those courts. In the Supreme Court judgment, which has released on 4/11/22, it has specifically mentioned that they relied on the judgment in case of R.C. Gupta. And the provisions have been crystallized. The word has been used by the Supreme Court of India, is crystallized in R.C. Gupta case. They upheld the case law of R.C. Gupta. Thereby, they have given an extension of 4 months time from date of 4/11/22 to those persons who could not exercise the joint option under 11.3, which has been repealed. And continuing in 11.4, they will be given a chance for another 4 months from the date of the judgment to exercise the fresh option. At the same time, they have also mentioned that those employees who could not exercise under para 11.3, where there was no cut-off date, are not entitled for any relief under the judgment. At the same time, Supreme Court of India, Honorable Supreme Court of India stated that they have given ample scope for the department authorities to craft their own schemes and generate their own funds in lieu of 1.16 extra contribution to be sought in by the employee. The operation of the requirement under para 11.4 of 1.16 extra contribution has been suspended for a period of 6 months. And they have advised the department to make their own arrangement to procure the funds. Simultaneously, they have also advised that they don't speculate as to what the department has to do. They can look at increasing the contribution, and also they look at what to call calculation of pensionable salary. And several things they have stated, but they said that categorically they don't want to speculate anything on this particular matter, left to the discretion of the department. At the same time, there was a plea earlier that the computation of pensionable salary on average 60 months was illegal and erroneous. But Supreme Court held, Honorable Supreme Court held that they did not find any flaw in the computation of pensionable salary. While it is so, the Employees Provident Fund Organization, while they are releasing the unified portal, made certain restrictions in the portal, almost making the joint application highly impossible. The restriction was they connected between para 26 obligation to para 11.3 application of EPS95. If we analyze the para 26 obligation under Employee Provident Fund scheme relates to only contribution of Provident Fund, but not the pension scheme. Why? Because pension scheme arose only in 1995. That means almost after 43 years of EPF scheme came into existence, the employees pension scheme came into existence. But by taking clue from different parts of the judgment, they might have read the judgment alone without having a rationale behind how Supreme Court, how Honorable Supreme Court has arrived at a conclusion. There was a word in R.C. Gupta, opting under 26.6 is a precursor. They might have used that particular word into consideration and might have told and might have put that particular 26.6 as a immediate requirement for opting for the higher pension in the joint option. So according to my knowledge is concerned, I have gone through various Right to Information Act material. I found that there is no single organization across entire India which has applied for 26.6 option and got permission from an official not below the rank of the APFC. While it is so, there are several judgments which are there in place. For example, I will take the state of Jharkhand versus Srivastava. It was held by Supreme Court in 2013 that pension is a matter of right, which is a fundamental right, which can't be denied or stopped or reduced because of procedure of law, due compliance of a law. This is the main judgment given in that particular case. I think which is also quite a suitable thing when the EPFO officials ask for 26.6. While it is so, I bring to your knowledge, there are so many exempted establishments across country and also an unexempted establishment in the country who have contributed to the actual salaries of their employees, which are more beneficial. And moreover, coming back to this exempted establishment, Section 17(1)(a) of Employees Provident Fund Act 1952 provides for a provision for a private establishment to create its own fund, to run its own fund in its own fashion, but subject to the conditions and stipulations of investment as declared by the EPFO only, but not on their own. At the same time, the permission is given, the exemption is given on a condition that they provide more beneficial legislation or a more beneficial legislative aspects into the scheme. That does mean it is an automatic deemed permission given, saying that you can contribute more, or you can give more interest, or you can give more loans, or you can give loans in a lesser period than prescribed by the Act. Several things are there which are beneficial to the employee. That means almost that practice lived in the country for more than 43 years before EPS95 has come into picture. More so, there are 1,552 exempted establishments as per the website information of EPFO. Almost I think so. All have contributed more than the required salaries towards the PF contribution. So according to me, I have to take two things differently. Para 26 is different and para 11.3 is different. Para 11.3 is speaking about only pension, but para 26 is speaking only PF. There is a difference between PF and pension. Before pension existed, PF existed. Okay, linking casually with that, then this, I think it's not a right approach taken by the EPFO. And secondly, recently on 15th March 2023, in Kerala High Court, a group of persons from BSNL who are working in the BSNL filed a writ petition. They sought a writ of certiorari and writ of mandamus against the requirement of 26.6. They pleaded before the Honorable High Court, saying that they can issue any writ as they deem fit, but they found, according to them, this particular requirement of 26.6 comes under certiorari and mandamus. The writ of mandamus and certiorari are almost similar in nature. So that is a writ given by the High Court against a public authority if they perform their duties more than the requirement. They led their case in such a way, either they wanted that particular 26(6) to be deleted from the joint option portal, or this particular to be given in a or some other provision to be given, or they may be allowed to put the application in what to call hard copy, and also requested that in view of employer contributing more than the statutory wage, the operation of 26 is only a formality. It is deemed to have been given. The 4 different kinds of pleas they have put over, and accordingly Kerala High Court admitted the writ. Actually, Kerala High Court admitted the writ and given notices to Government of India, the Regional Provident Commissioner Thiruvananthapuram, the Regional Employees Provident Fund Organization Pension Section to Delhi, and also to Bharat Sanchar Nigam. And they have been given time up to 23rd March to submit their counter. Then we have to wait and see as to what is the counter they are going to submit. Be it the case, there are 4 review petitions pending for the retirees, pre-retirees of 1/9/2014. And we have to wait and see how Supreme Court of India, Honorable Supreme Court of India, will review the petitions of pre-retirees of 1/9/2014, and what verdict they are going to give. Well, because already in the judgment dated 4/11/22, they have mentioned that pre-retirees of 1/9/2014 are not eligible to those who did not apply for it, apply for the option when they are when there was no cutoff date, when there was no confusion, when they were not able to apply before 1/9/2014, are deemed to have been not applied, and those people are not allowed to they will not be given any benefit under this particular judgment, is the verdict given by the Supreme Court of India. If we look at it in a particular fashion, correct. Before this para 11.4 has been introduced, in 11.3 there was no cut-off date. So only they said that whenever the employee exceeds the statutory limit, they can opt for the scheme, and it was misinterpreted in a different way from different corners and quarters, and hence that particular 11.3 has been repealed and 11.4 has been introduced. This is all my analysis only. I am not claiming it as a pakka statement. I made this particular video only because keeping in view of certain requests made by certain people saying that I must make one video in English also. Why? Because my Telugu videos are also running across the country by the Telugu people, especially in Andhra and Telangana. So since some people have requested me to give an option, give a brief video in this particular English also, that's why I am giving this particular video in English also. And a third aspect of this particular thing, what I would like to mention is, we need not worry, we have to wait for several judgments, several pending writs which are coming up. And moreover, the advice what I can give to the exempted and unexempted establishment is, while filling up the option by the exempted establishment, you may prefer to put your rules into consideration under the para 26(6) requirement. While unexempted establishment may put their latest contribution card showing their contributions have been paid in excess of the statutory limit and actual salary. This is only nearest to proof what you people can show it to. Why? Because the requirement under para 26, barring the permission to be obtained by the APFC, is only contribution on higher wages. Already it has taken place. You need not worry. The PF department has accepted the higher contributions from the unexempted establishment also. They have audited their units, and they have given interest, and they enjoyed the additional benefit of additional administrative charges also on the higher wages. So now at this particular point, they can only treat your unit is a deemed permission and all. I don't know how they prefer to interpret this particular thing going forward. And moreover, we may have to wait the Central Board of Trustees meeting on 27 and 28, which is going to happen in this month only. I heard from different sources that they are going Ministry of Labour and Ministry of Finance and the central government and EPFO all are putting their efforts to establish as to how they can run the fund. And EPFO has been strictly instructed by the Ministry of Labour to what we call rework the budget. Why? Because while they are preparing the budget for 22, 23, 23, 24, when they are finalized in the September, they did not take into consideration the impact of Supreme Court judgment, which has been released on November 22. So now they have been advised to take the impact of November 22 judgment also into consideration and reallocate the funds for the discussion and send it to the Ministry of Finance for necessary approval. And in the meantime, they are preparing an agenda for 27, 28 meeting also concerned. So once all these things comes together in a particular fashion, then we will be able to demystify everything. When I say demystify, the Supreme, this EPFO also is planning to demystify the Supreme Court judgment in its own way. I don't know how do they do it, and we are expecting that demystification in another couple of days. So thank you very much, my dear friends. I think this will clarify many of the doubts of the people. So I made it only at the request of some people. We said that there are many people who do not understand Telugu, and for them you kindly make one video, and depending upon their request I made this video. Thank you very much. I will make one more video in English after everything has been settled out and our new things are coming up, and which are of much importance, which is to be known by the members. Thank you very much.